Thank you for joining us today for our webinar on the Indian Child Welfare Act and best practices for attorneys. My name is Ansley Sherman. I'm Muskogee Creek, and I'm the program attorney for the National American Indian Court Judges Association. I'll be moderating today. We want this to be as interactive as possible, so please feel free to ask questions throughout and to make use of the chat feature to connect with one another. Today we have Victoria Sweet presenting. She's the Assistant Director of Tribal Law and Justice Consulting at the Whitener Group. She is also a board member for Partnership for Native Children, which is a nonprofit whose mission is to get more accurate information to the press, media, and general public regarding Native children and the laws that protect them. And with that, I'll turn it over to you, Victoria.
Thank you, Ansley, and hello, everyone. It's a crazy time of year to be getting on a webinar, but I'm excited to have an opportunity to spend a little bit of time with you today talking about the Indian Child Welfare Act. Just so that most of you know, the slides and the basic information I'm going to be giving is sort of the foundational backbone information about ICWA. I'll do my best to keep my eye on the chat box so that I can see questions that are coming in. And one of the reasons that we make the PDF of the webinar slides available to you is that if we don't manage to get through all the slides, you still have that information. You can still access it, and you can also reach out to me. My information will be at the end if you have follow-up questions and you want to discuss any of the information that was presented today. So welcome, Judge. It's nice to talk to, nice to hear from you, and feel free to introduce yourselves so that you can also interact with one another if you would like to while the webinar is going on. So we're going to just jump right in to talk about the Indian Child Welfare Act. And I'm going to start with a survey of a couple of questions, and I'm going to ask you to rate something on a scale of 1 to 5. So if you would like to go ahead and put it in the chat box, that would be useful to me just so I can see a little bit, since we're not in the room and I can't see your faces. This will give me a little bit of an idea of how you feel about some of the issues that we're going to talk about today. So the first question I would like to ask you, someone just said they can't hear the audio. Is everyone able to hear the audio okay, other than Heather? Okay, so it looks like other people are able to hear. Heather, I'm not sure, our tech person is going to work with you to see if they can fix that. Sorry about that. All right, so here's the first question. On a scale of 1 to 5, with 5 being the highest or most harmful, how harmful would you say removal is for a child? Nice. Yes, we have been finding that removals as they've done data and the social scientists and others have been researching it, even in situations where a child definitely needs to be removed, where there is potential danger to this child, there is still harm that occurs to a child when they are removed. There's still trauma. It still can negatively impact a child to be removed from the home, even under the most pressing and most dangerous of circumstances. All right, here's another one. On a scale of 1 to 5, 5 being the most, how important is kinship placement? Nice. So I'm seeing, again, pretty much 4s and 5s from most of the participants. Again, in the best practices world, when we're talking about child welfare practices, more and more research has been done that shows that if you can keep a child with family, extended family, or their community, that is going to be the absolute best option if you're going to be taking them out of the home. There's still harm that can occur. There's still trauma that occurs from removing. But if you're going to be removing, if you can keep them in a sort of a kinship setting, you're going to be able to reduce the trauma that this child is feeling. All right, the third question. On a scale of 1 to 5, how much influence do you think a court can have in reducing the trauma of the children and youth who are involved in the system? 5 being the most influence and 1 being the least amount of influence. Nice. So again, a lot of 4s and 5s. A couple 3, there's a 3 there. It's an interesting question, but at the National Council of Juvenile and Family Court Judges, at the National American Indian Court Judges Association, and other organizations, they are starting to find that when we are being trained on things such as the potential traumatic and harmful impact of removals, the importance of kinship placements, and so on, that some of the choices that we make in the court systems can actually increase or decrease some of the trauma that these children and youth are feeling if we're paying attention to the research, if we're paying attention to the laws and to the science and to the research and figuring out how best to work with these children and how to try to reduce their trauma. Now, the reason I'm starting with these 3 questions is because this is what we know of as some of the best practices, some of the emerging practices in the child welfare field right now. Then I go and I talk about the Indian Child Welfare Act. And many people are surprised when I tell them that the Indian Child Welfare Act actually encapsulates and incorporates some of these best practices. Even though this law was written back in the 70s, it is actually incredibly responsive to what we know of as best practices in child welfare today. And so I want to spend a little bit of time as we're going through and talking about the actual how-tos with ICWA, that we also recognize that woven through this law are actual best practices that many people are looking at when they are working with all children. Even when they're talking about how to best work with non-Native children, any children in the system, the foundation of doing what we can to try to prevent removals, to try to keep them in placements that are kinship or extended family or community placements, and then working on our internal policies within our system to try to be more responsive to the potential trauma that these children are going through. It's all actually in this law. The Indian Child Welfare Act was actually implemented in response to public policies that induced and created trauma in children and families. There are not many federal laws out there that are actually designed to repair damage that the federal government created through some of the policies that it implemented, but ICWA is one of them. I look at these pictures. These are pictures that when I think of ICWA, the first thing I think of are these pictures. I think of these stories. I think of the history of how the federal government used to come into Native communities with the intention of saving our children, and they put them in these boarding schools. They removed them from their families. They did the exact opposite of everything that we know of when we talk about reducing harm to children, preserving families, all of the things that we really value in the child welfare system today. So as I mentioned, ICWA was created specifically with the intent of righting wrongs. So when we talk about ICWA, it is a law that is designed specifically for the Native community and for righting wrongs in the Native community, but I also want you to just sort of remember some of those questions at the beginning that I'm going to refer back to and think about how some of these things that we're implementing, while they can be frustrating for some people. I do a lot of training on ICWA, and I've gotten a lot of feedback from people saying, but there are all these requirements and it's exhausting. I've sat in a courtroom where someone says this is an ICWA case, and I've heard people groan out loud because it's true. There are some requirements. There are some things that that can be time-consuming and that you're not used to having to do. But if you look at it from the perspective of best practices in child welfare in general, I think you're going to see that there's some real benefits to implementing the Indian Child Welfare Act, and maybe we can reduce some of the negative pushback that we get when we start talking about ICWA. I think that we get a lot of pushback, number one, because people don't necessarily understand the law. So that's part of what this webinar is going to do today, to hopefully empower you. So if you feel like you're not 100% certain about what you're doing with the law, this can give you some of the nuts and bolts information about how to be able to implement appropriately. There's also a huge misunderstanding, and I've seen this has been raised in some court cases, and we'll touch on those in just a minute. But some people say, well, isn't this a racial law, and wouldn't that be a violation of equal protection? That's actually inaccurate. So I want to make sure I dispel that right from the beginning. According to federal Indian law and laws that have been in place since the Supreme Court precedent that's been in place since the 1800s, I should say, the Indian Child Welfare Act is based on the concept that tribal nations are political entities. They existed prior to the existence of the United States government, and they developed a nation-to-nation relationship with the United States government. And because of that, laws that talk about certain things that are specific for Native communities are based on the political identity, not on the fact that they are a racial or ethnic group. So we need to really make sure we are emphasizing that point, because there seems to be a lot of misunderstanding in the general public and in our legal community that this is somehow a racial or ethnic law. It's not the case. This is political identity, and it falls under a completely different category. I already mentioned this, but sometimes we get pushback because judges, attorneys, social workers, others, we get tired. It feels like a burdensome law. But then I'll do a training for a judge who will say, I was thinking about all the stuff I learned about ICWA and realized these very same principles apply with this immigrant child that I'm dealing with who's from a different community, or this other child who is from a really tight-knit community somewhere. And I think that changing our focus about how we talk about it and really talking about best practices in child welfare in general helps us not feel like it's as burdensome, and reminds us that this law really is encouraging a higher standard and a higher level of care for the children that it applies to. We also get pushback sometimes because, quite honestly, family law is generally a state or local type law, and every time we get federal interference, some kind of federally unfunded mandate to the states, we're going to have pushback. And then the other big thing that I hear regularly is that people think it doesn't apply. So a child will come in, or a family will come in, and if they do not look a certain way, they assume they don't even consider the fact that this could be a Native child that might be involved in the case. Or they live in a state where there may not be any tribes, or just a couple of tribes, and they just don't think that they're going to be having ICWA cases. And I try to remind people on a regular basis, you cannot tell if this is going to be an ICWA case purely because of where you live or because of how someone looks. There's been a lot of intermarriage over the years in the Native communities as well as other communities. I am Native, but if you could see me, I have fair skin and I have blue eyes. That does not make me any less Native. It simply means that genetically that's how I ended up looking. You cannot tell by looking at someone. Also, I think it's important to remind people that only about 6 to 7% of Natives actually live on our reservations. We are dispersed throughout the country. We live in urban centers, we live in rural centers, we don't necessarily live on reservations. So whether someone has federally recognized tribes or state recognized tribes within their communities and in their states does not necessarily say whether or not they're going to have an ICWA case. So I wanted to address those just in case any of you who are listening are in those situations where you're wondering why are we focusing on ICWA so much. One of the things that we're going to talk about has to do with inquiry. We have to always ask, I had one judge, when the first time she did ICWA training, she said, I never get ICWA cases. I don't know why we're being trained on this. And then she was reminded that she needed to be asking. She started making the inquiry, and she laughingly will say, suddenly I had ICWA cases in my court. So it's amazing how many might pop up when we actually follow the law and ask the questions. I also want to quickly, I'm not going to spend a lot of time on this because this webinar is not about lawsuits, but there has been one lawsuit recently that gained a lot of press. It happened in the Northern District of Texas, and it was a case, Brackeen versus Zinke, or Texas versus Zinke, depending on how you've read it. But there was a judge in that district, that federal district court, that decided that ICWA violates equal protection and violates the 10th Amendment, and I put the 4 findings there on your slide. I want to just quickly mention that, first of all, it is an outlier case, and second of all, when I made this slide, the motion to stay the decision had not yet come through, but the Fifth Circuit did stay this decision. So for the time being, the Texas v. Zinke or Brackeen versus Zinke case is not applicable anywhere because it has been stayed by the Fifth Circuit. I understand that the Fifth Circuit has approved the motion to expedite the hearing, the appeal on this. So there will be an appeal sometime in 2019, so we'll be watching for it. But as of this time, the decision in that lawsuit is not applicable anywhere in the country. So I just wanted to make that clear. That is December of 2018, in case anyone listens to the recording of this webinar later. As of right now, that's where that lawsuit sits. So let's talk about the law. First of all, I mentioned already really briefly, the original Indian Child Welfare Act was passed in 1978. I think it's interesting that here we are in 2018 and there are still quite a few people who don't even know about the Indian Child Welfare Act, and we are still really struggling with implementation of an act that's been in place under the federal law since 1978. A year after, or shortly after the actual law was passed, there were some guidelines that were passed to try to clarify some ambiguous areas and help people understand a little bit more about the intent of the law. And then, for the most part, things went pretty quiet until 2015. And in 2015, there were some new guidelines that came out. Guidelines that sort of helped clarify things that had been difficult around the country when it came to ICWA implementation. Then in 2016, we got new regulations. And I really want to stress the word regulations, not guidelines, because guidelines are sort of advisory in nature. The regulations are intended to be mandatory. So new mandatory regulations came out in 2016, and then shortly after there were some revised guidelines, again, designed to sort of provide a little bit more background in gray area and a little bit more background in the intent of what was meant by the regulations and by the law. So I hear people use the terms regulation and guidelines interchangeably. I want to really highlight that we shouldn't be doing that. Guidelines are purely meant to advise and provide a little bit of extra guidance, but regulations are intended to be mandatory on all of us in the court system. This is the actual definition that came from the law, from Congress, that talks specifically about the best interests or best needs of an Indian child. I want you to take a look at that language and see how it is slightly different from how other people talk about best interests of the children. So on top of the things that you would normally look at and say, here's what the best interest is for a child when we're determining whether or not a child needs to be removed, there's also this piece within ICWA that says that retaining that child in their culture and finding culturally appropriate placements is something that best serves the need of an Indian child. There are new publications starting to come out now where Natives who were taken away from their families and communities as children are starting to go back and talk about the experiences that they had when they were placed outside of their communities. And across the board, whether they were in a really negative placement where it was abusive and difficult, or whether they were in a really positive placement where they felt like their non-Native families were good to them and that they were loved, there was still this level of stress and this level of anger and this level of feeling like something was missing in their life that every one of them as adults talk about. So one of the lessons that we're starting to get from those who have been removed is that we really need to take this concept of doing what we can to keep the child connected to their culture very seriously. There's an entire powwow that is held every year simply to help those who have been adopted and placed away from their communities to find a way back because of the expressed trauma and sadness and sense of loss that so many members of this community have felt and have expressed as adults looking back on their lives. Just to make sure that we also all know what we are talking about under the law, who is an Indian child? What is the actual definition for the purposes of ICWA? This is the federal definition. If you happen to live in a state that has a state Indian Child Welfare Act or some kind of court rule, you want to make sure you're checking that because there are states out there that have expanded upon this definition. But this is your basic, most minimum definition. So you're looking at an unmarried person who is under 18, and they're either a member of a federally recognized Indian tribe or eligible for membership in a federally recognized tribe, and they are also the biological child of a member of a federally recognized tribe. So that is your basic definition when you're trying to determine, and don't miss the piece that sometimes they may not have gotten their official membership with their tribe yet, but if they are eligible for membership, this is still going to be under the definition of an Indian child for the purposes of ICWA. By the way, if I start going fast because I can't see any of you and you want me to slow down just a little bit, please put it in the chat because I can't see if you're following me or if I tend to talk fast when I get excited. Sorry about that. Inquiry. Inquiry is something that is a bare bones necessary thing to be talking about. When you look at Indian Child Welfare Act appeals across the nation, one of the biggest things that are appealed is the fact that people never made the initial inquiry. So when you're dealing with an involuntary proceeding in a state court and it says where the court knows or has reason to know that an Indian child is involved, and then there is requirements upon you, how will you have a reason to know if you do not remember to ask the question? So part of the law, and especially part of these updated regulations that came out, talks about the importance of asking every party involved in this involuntary hearing if there is a chance that they could be Native or they could potentially be members of a tribe or eligible for membership in a federally recognized tribe. And if someone says, well, yes, my mom or my grandma or somebody is from such and such tribe, you suddenly have this reason to know that this could be an Indian child. There are some states that have expanded upon what reason to know is, so I challenge you to make sure you check within your own state to see if there's any case law that tells you what that is. That's a little bit of an ambiguous phrase, but I tend to err on the side of caution. So if there's reason to know that this is an Indian child, that means you're asking from the start of these involuntary proceedings if that's the case. And I will say that as an attorney, if you're representing parents or you're representing a child, asking so that you know what's going on and if you potentially have an ICWA case is very important. As well as for judges, we remind them that they need to be asking because sometimes, because of trauma that has existed maybe in this individual family or potentially trauma just within the community, fear of having your children taken away from you purely because you are Native, and that has happened in multiple situations, there are people who will hide it. And they will not mention it to the social workers necessarily. But if they have an attorney representing them or they see the judge and they realize it's important for somebody to know, they will mention it at that point. So that's why we really emphasize that you ask at various stages through the proceedings and not just assume that everyone will know by the time we actually come to that first involuntary proceeding. And here's the actual language that comes from the regulations in case you want to see it. The inquiry needs to be made at the commencement of the proceeding. the responses need to be on the record. So that's especially important for judges, and if you're in a hearing as an attorney and it's not being done, it's an important thing to make sure the record is complete, that we remind people that in this case, this is a requirement under the law. Also, judges are expected to instruct the parties to inform the court if they subsequently find out that there is reason to know that this child could be an Indian child. Then, if there is reason to know, but maybe there's not sufficient evidence at the moment, so that's the type of hearing where suddenly your client who this parent has never once mentioned that they could be Indian, all of a sudden they say, well, actually, my grandma was from such and such tribe, but you don't have the determination yet because the law specifically says that the only one that can determine whether or not a child is eligible for membership is the tribe. So if they have a card, a membership card, a CDIB, something like that, some paperwork from the tribe where the tribe acknowledges, yes, this is an Indian child, the tribe has made that determination. But if you don't have that, then here's the requirement of what you must do. So first of all, you confirm in some way that the agency or parties use due diligence to identify and work with tribes. So you may have to say, all right, we're going to have to stop this right now because we suddenly may have an ICWA case here. Now, agency, you need to be able to you have to show that you use due diligence to identify whether or not this child is an Indian child, whether or not this is an ICWA case. And then the second one, which is where a lot of people get frustrated, but it is the requirement, which is you treat the child as an Indian child if you have reason to believe this is one, unless and until it is determined on the record that the child does not meet that definition. So if you've been given reason to know, you are to move forward as if this is an ICWA case, unless and until a tribe comes back and says, no, we're sorry, this child is not. It gets complicated with private adoptions, especially in a step-parent situation. But yes, if this child is a member of a tribe, the tribe is going to need to be involved in the proceedings. And I have a little bit more information coming up about adoptions. Generally, in my experience, if you have a step-parent that is planning to adopt, alerting the tribe, tribes are very rarely going to step in and say, well, we don't like this, we don't want this step-parent adopting. It's usually not a contentious issue, but just because, well, here's the biggest thing that comes with not having our inquiry done right and not asking about ICWA from the start. If we get down the road and then someone comes in and says ICWA does apply and there's a bit of a fight, you're going to find these cases taking longer and staying in the courts longer. If we notify the tribe right from the start and just let them know that some things are changing, for the most part, that's usually your best practice, and that's what I recommend. There's a lot of, I'm just going to say when it comes to private adoptions, step-parent situations, there's going to be a lot of different opinions out in there. If I'm going to give you a best practice recommendation, that's what I'm going to suggest that you do. I hope that helps a little bit, Stacy. Another thing, oh, I see that there's a couple more things. And also, as I said, I'm going to have my email address at the end. So if you want me to maybe send you some quotes from the regulations or put you in contact, if you tell me what state and there's a specific question, I could put you in contact with someone that can talk to you about any specific case law where you are, that might help. Let's see, New Mexico removes prior to the filing of the petition. Tribes are notified about the proceedings where the parents are without. Okay, yeah. Yeah, thank you for that, Cindy. New Mexico actually does some really interesting things, and there are quite a few state judges from New Mexico that I have worked with and trained, and I think that they have been trying very hard to make sure that the tribes are very involved in these cases. Like I said, we all know that removing children is a stressful experience on the child and on the family. We, as a rule in our child welfare systems, do our best to not have children in the system for very long. When we get the inquiry part wrong, when we get the notice part wrong, which I'll be talking about in a little while, we end up with situations where these cases stay in the courts longer. They don't stay in the courts longer because of ICWA. They stay in the courts longer because of errors made in the beginning, which then causes us to have to start cases all over again or have to step back and redo hearings to be in compliance with the law. So that's why I really, really push the inquiry and the notice pieces of ICWA a lot. It reduces a lot of time, a lot of stress, a lot of time that these children are stuck in the system, and a lot of cost, quite honestly, for the courts and your time and the judge's time. And so I'm going to push the inquiry and the notice a lot when I talk about ICWA. It's also important to understand the piece about jurisdiction. So who has jurisdiction over certain types of cases? Well, for the most part, the tribe is going to have exclusive jurisdiction in cases when the child is domiciled or resides on the reservation. I'll talk about the domicile definition in just a minute. Or if this child is a ward of the tribal court, so there's, even if maybe they've moved off of their tribal lands for a little while, if there are previous cases that have been filed in tribal court and they have sort of a ward relationship with that tribal court, then that tribal court has exclusive jurisdiction. The state is going to be having concurrent jurisdiction with the tribe in situations when the child is residing off the reservation, those types of things. But remember, this is concurrent. It is not exclusive for the state. That means that we still need to be talking with the tribes. We still need to make sure that they are being given notice. And we'll talk about some of the other pieces that go along with it. But I think it's really important to understand in some of these cases, if you find out that that child is technically domiciled on the reservation, then you're dealing with a tribal exclusive jurisdiction situation. The domicile definition is in the new regulations that came out in 2016, and it's going to sound very, very similar to any other definition of domicile. So you have a residence. Usually what it starts with is you look at the parents of the child, and you look at if the parents are separated, whichever parent has primary legal custody of this child and primary physical custody of this child, you look at where is their primary place of residence. And is this a place that maybe they've left it but they intend to return to it? That sort of concept, like I said, it's sort of your standard domicile language. That ends up being then their legal domicile, and then the child's domicile is the domicile of their parents. We see questions come up where we have maybe a family that has left the reservation. Maybe they're doing seasonal work, so they're living off of their tribal lands for a period of time while they're following the agriculture, let's say, or something similar. But their home, their primary residence, is still back on their tribal lands. They're fully intending to return to their tribal lands and live there. They're just living temporarily away. That would make their domicile in their tribal lands and would make the jurisdiction then the tribal court's jurisdiction. So understanding that that's what we mean by the domicile of the child, it can help when some of the jurisdictional questions get a little sticky. And there's also an issue with emergency removals, but I'll get to that in just a minute because that's its own category. I mentioned that there's inquiry and notice are the two provisions that I'm going to really, really stress. These are the two provisions that are the most appealed provisions when it comes to ICWA cases across the country. The question of notice is something that we consistently are not doing well in state settings for a lot of reasons. Sometimes we assume that the agencies have already done it, and sometimes people are really confused about how you even go about giving notice. So the law specifically says that the agency or court shall notify the parent or Indian custodian and the Indian child's tribe about pending proceedings and their right to intervene. It's important that we separate those two out. In other cases, you generally have the state and then you have, the parents, the family. But in ICWA cases, the tribe is a third party with guaranteed rights under the statute. So they need to get their own separate notice under the law. That's very important. And And one of the things that you have to let them know about is that they have the right to intervene. They have the right to intervene at any point in the proceedings. Now, intervention does not necessarily mean that the case is automatically going to be transferred away from state court to tribal court. Sometimes it will not. Sometimes intervention means that the tribe would like there to be a social worker attending the hearings, whether in person or over the phone, maybe participating in case planning, and that's just that they are being notified and aware of all the different steps that are occurring in the case. They may choose, yes, sorry, was there a typo on there? The parent or Indian custodian. Usually you're going to have one or the other, and that's just the way it's written. I believe if I made a mistake, please let me know if you look it up and you see that it makes a mistake, but I think they usually say parent or Indian custodian. And if you have both, obviously both should definitely be notified. All right, thanks. I appreciate you guys keeping me on my toes. I've been sick and it's the holidays, so I am absolutely open to the fact that I could say something wrong right now. So I really wanted to highlight, though, that intervention does not necessarily mean transfer. Transfer is something that could be part of an intervention, but don't expect that that necessarily means it. And I'm actually going to go back to this slide about notice. I don't know how many of you have dealt with giving notice in ICWA cases, but there's a couple of things that are key to point out. First of all, the notice needs to be given. Let me make sure there's not a slide here. We'll get to that timeline in a minute. There needs to be a notice that has to be given either registered or certified mail. This is an important key because if there is a question about whether or not proper notice was given, you want to have that form that you get with either registered or certified mail that specifically states, that shows the date, it shows the date that it was received, it shows who received it, because then you can go back and you have a paper trail to make sure that you were fully in compliance with the law. So that's one of the things that the law requires. You also have to make sure that it is going to the right place. So the Federal Register actually publishes every year, first of all, a list of every federally recognized tribe in the country. So if you're trying to find a tribe, there is a Federal Register list out there where you can look up every single one of the 573 federally recognized tribes in the United States and find out their names and where they're located and so on. They also publish a list of ICWA representatives. So of course, they're not always going to be up to date. Sometimes there's turnover and the name hasn't been given over to the federal government yet so that they know. But for the most part, you should be able to find the appropriate ICWA representative to send your notice to through that Federal Register list. That should make life a lot easier because we've had situations where people have sent notice. In one particularly crazy situation, the tribal newspaper received all the legal notifications about this case, including some information that really should not have been outside of the eyes of someone working in social services or enrollment or the courts. So double checking and making sure that the notice is going to the correct parties and that it was received on the correct date is key. It used to be that you could only do registered. Now you can do both registered and certified. Here's the timeline. This is another reason why it's essential that you get your notice correct. Under the law, they have to receive notice 10 days prior to a hearing. So if you cannot demonstrate that it was actually received and you have a hearing that's scheduled, this hearing might have to be rescheduled to follow the timeline. And the law also allows them to request an additional 20 days to prepare for the hearing. I know I get a lot of questions about this. Sometimes that can interfere with state mandates, state laws, state court rules, etc., about when hearings need to be held, but this is the federal standard for an ICWA case. So I just wanted to call that to your attention and highlight why notice is so essential. I mentioned earlier a little bit about removals and about jurisdiction. ICWA does allow for an emergency removal of an Indian child who is off the reservation in order to prevent imminent physical damage or harm. So it is possible that this child could technically be domiciled on the reservation, so technically this would be an exclusive tribal court case, but there is some type of imminent physical damage or harm. Obviously, there is no one wants this child to be injured or harmed in any way. So there is this very, very temporary thing that allows a state court to have jurisdiction in an emergency situation. But this is the standard you have to meet. You have to demonstrate that there was imminent physical damage or harm to the child for the state to be able to exercise this emergency removal jurisdiction. It used to be also that the state could use this emergency removal jurisdiction power authority, and then they were able to keep this child for 90 days without a hearing. That has now been changed under the regulations that came out in 2016. So the time period for temporary custody without a hearing is now 30 days, except in some kind of extraordinary circumstances. Now, if it turns out that this child is going to need to remain in court custody after the 30 days, then at that point, you need to make sure that your hearing is completely in compliance with any other ICWA hearing. So with an emergency hearing, you may not be able to meet some of the ICWA standards that we're going to talk about in a minute, like a qualified expert witness or certain other types. Those are really hard to do in an emergency setting. The law recognizes that, but if you are keeping this child in custody for more than 30 days, you're going to need to make sure that you are now holding a hearing that is fully in compliance with ICWA. Does that make sense to everyone? So there's this emergency removal authority can be a really sticky point, and I think that's why they changed it. I mean, 90 days without a hearing was a huge, huge problem for these parents whose children have been removed from them, and they don't even have the ability to have a hearing to be able to try to demonstrate whether or not they should be reunited. And then this is the rest that it talks about with these emergency hearings. The child must be returned home as soon as the threat of imminent physical harm has passed, or the tribal court asserts jurisdiction in this case, whichever one happens sooner or earlier. And then, and this is what I was just barely referring to, the language says that you need to expeditiously initiate a child custody proceeding subject to ICWA if the child's not being returned. So that's just in case you want the actual language from the law. That's what it says. So I started this whole thing by asking those questions about best practices, and I said the Indian Child Welfare Act actually does demonstrate, does encourage many of what we consider to be best practices in child welfare cases across the board. So how does ICWA help reduce removals and terminations? First of all, you have a heightened burden of proof. So in order to remove temporarily and place a child in foster care placement, you have to use clear and convincing evidence that continued custody of that child in that family setting is likely to result in serious emotional or physical damage to the child. And this clear and convincing evidence must include the testimony of a qualified expert witness. I'll talk more about a qualified expert witness further down, but it's important really quickly to mention a qualified expert witness is the witness of the state. It is not the tribe's witness. It is the witness of the state. So it's the state's responsibility to get a QEW, and I recognize that is not always the easiest thing, but sometimes there is confusion with people who work with the state, and they say, well, shouldn't the tribe be providing us with a QEW? No, that's not under the law. That's not required. However, I hope that those who work in states and those who are in tribes are starting to talk to each other more, because it's in everyone's best interest to find appropriate qualified expert witnesses to help expedite these cases and move them a little bit faster. And so we can talk a little bit more about what that means and how you go about finding a QEW, because I know that that's tricky. But I just wanted to, I have had a case where a tribe was calling me and the state was telling them that they had to provide the qualified expert witness and pay for them, and that is not the case. This is a witness that is going to be testifying for the state on whether or not the state's recommendations are accurate, and they need to have knowledge and understanding of the tribe in order to be able to do it appropriately. But it is technically considered the state's witness. I hope that is clear. So one way, this heightened burden of proof, having a clear and convincing evidence standard, is one way that it's a little bit tougher to be removing unless you can demonstrate with this higher burden of proof that the removal is really necessary. I see some people typing. Sorry, I'm trying to watch for any questions or comments before I barrel through the rest of the information. I'm going to put the next part of the slide up, and I'll come back if there's a question about that. And then when we're talking about terminations of parental rights, you need to meet the burden of proof as of beyond a reasonable doubt. And again, including the testimony of a qualified expert witness. So you have to be able, in order to completely terminate some parent's rights to their child, you have to be able to demonstrate to that level that continued custody is likely to result in serious emotional or physical damage to the child. So having these heightened burdens of proof are designed not to make it impossible to remove a child, because we clearly know there are times when that absolutely has to happen, but to make it a little tougher sometimes to be removing, and particularly to be terminating parental rights completely. The parent wants to admit to the petition that the tribal representative in court is not the person that's to sign that qualified expert witness affidavit. So the tribe is participating, the parent wants to admit to it, but it sounds like whoever is in court then is not a QEW. I'm sorry, I'm trying to make sure I understand the question, Heather. But if the tribal representative is not going to be the person who signs the QEW affidavit, you have to have a separate qualified expert witness, because the tribal representative's whole job is simply to represent the tribe's position in the case. The QEW has a different responsibility, which is to testify as to whether or not the state's case and the state's proposed actions are appropriate in this particular case. So as the tribe is participating, that's wonderful, but you still have to have a separate QEW to sign that affidavit. The tribal representative generally is not the one who's going to be able to do that. Is that kind of what you were getting at? This is the one time I wish I was face-to-face with you so I could ask questions and see your face a little better. And I apologize, everyone. I see that Heather is typing, so I just want to wait and make sure that I'm addressing her question appropriately. But I know that there are judges that I have trained and worked with that really do wish that these heightened burdens of proof were required in all cases, because they have had many cases that have come before them, and it just seems like in some instances, children are being removed, and there are a lot of questions about whether or not the removal was really necessary, or if they could have been safe, and there could have been another way of approaching the case. So that is one way that ICWA really does help deal with the traumas for children and for families for a lot of removals. Oftentimes we have a parent who wants to admit the petition, adjudicate the child, and have the county take temporary legal custody of it. Yeah, I know. And Heather, this is one of the very real difficulties. I am going to fully admit the qualified expert witness requirement is one of the trickiest requirements under ICWA. And when I train tribes, when I'm in Indian country and we're talking about ICWA and how we can encourage stronger ICWA implementation, this is one of the areas that we need to work on. We need to be providing as much support as we can to try to help the state find appropriate QEWs, because even under these circumstances that you're talking about, it is tricky because the law still requires that QEW testimony. And so you are at a risk of having someone come in and requiring you to redo that hearing if the state does not have the QEW available. So I 100% sympathize with what you're saying, and I can only tell you the part what the law actually tells us that we have to do. And I fully recognize that this is one of the trickier parts. I've been working with some tribes around the country who are actually doing QEW trainings and then working directly with the states when they need QEWs to help them find out who has been trained to be one, to try to reduce some of the complications with not having one. Oh yes, hey Krista from Sitka, Alaska. Sitka, Alaska, I'm just going to give them a shout out, is doing some incredible work between the state and the tribe there on figuring out how to build relationships and work better together, so much so that they actually just won a national award for all the incredible work that they are doing. So I just want to give them a shout out. If you're looking for a place that's doing it well, I would definitely talk to them and see a little bit, learn a little bit about how the state and the tribe there have been working it out. But QEW remains a really complicated issue. Unfortunately, even in situations like you're talking about, Heather, you could end up having to redo everything if you don't have proper QEW testimony. So whatever can be done to support each other in relationship build and try to get more QEWs available is what I'm going to recommend as a best practice. Yay, good. I love it when people start meeting each other and can learn from each other who are on the ground about how things are working. You have to also remember in the state, a QEW situation can be really tricky for a tribe because if most tribes, we're not that big. So I am Ojibwe. For those of you who don't know, I'm from the White Earth Band of Ojibwe, which is in Minnesota. Our communities, technically, we aren't that big. And so when you're asking someone to go be a qualified expert witness, which means you're a witness for the state, you could very well be testifying and saying that you think a child should be removed from somebody that you know and someone who's a neighbor, someone who is a community member. So sometimes it's tricky within our tribes to find people who are willing to put themselves in those positions and go be a qualified expert witness on behalf of the state in a case. So I just want to mention that that's one of the reasons, hey, I'm always happy to meet other Minnesotans, even if we're not face-to-face. But I just want to mention that that is sometimes where it gets tricky to get people who are willing to be a QEW in a case. But there's still this legal requirement, so we still have to come up with some solutions. And so I'm glad that some of you are going to potentially connect and see if you can come up with ideas on how to make that not as difficult of a requirement on you and on the actual cases that you're dealing with. I see that there's some more questions coming up, so I will come back to the chat. I'm going to keep moving through these slides to give us a chance to get through them if possible, because I tend to talk, and I apologize for that, but at least you all have this information in case we don't get through all of them. The whole question about transferring to tribal court. So when does a transfer to a tribal court happen? Well, first of all, under the law it says, well, when you're requested to do so, and there is no good cause to the contrary, and I'm going to talk to you all what we mean by good cause. It's actually spelled out, some of it's actually spelled out in the law. Neither parent objects, and the tribal court does not decline jurisdiction. So there's the good cause issues that we can talk about in a minute. If either parent objects to the transfer, this could be the native parent or if there's a non-native parent. If either parent says, no, we do not want this to transfer, the law says then we're just not going to be transferring it to tribal court then. So that's something that people need to hear. I've heard some people trying to say that ICWA is really egregious to parents, but parents are protected actually. Both native and non-native parents are protected under ICWA. And you also have to understand that sometimes a tribal court may decline jurisdiction for a number of reasons. One big reason that I have seen happen many, many times is that the child is in one location and the tribe is further away. And the tribe really wants child to be able to reunify with parent. Well, if they're transferring it to tribal court jurisdiction, and potentially that would mean a physical change for the child as well, the tribe may say, we don't want to do that. We really want child and parents to have the absolute best chance at reuniting. So we're going to keep everything where it is. We're going to trust the state in what's going on here. We want to be involved, but we're not going to bring it over right now. We're going to give it more of a chance where it is. Another reason might be that you have a case with a child that needs very special attention, and maybe this particular tribe does not have the particular treatment options or other types of options where it's located. Then the tribe may make the decision that it's in the best interest of this child to stay where they are and continue getting services through the state that maybe they can't provide. Another reason might be that the tribal court is very small, and either they don't yet have the ability to take a lot of child welfare cases, or they've reached the maximum number of cases that they can particularly handle. So sometimes when they decline jurisdiction, it's not that they don't want their children in the tribal court, it's that they have some other extenuating circumstances that make them believe it's best to keep the case where it is. All right, there are guardianships in state court. There's a change of circumstances for the parent such that there is a danger to the child. Should the child be, yes. So whenever there's any type of change in circumstances, you do need to be making sure that you are noticing the tribe and letting them know that there is a change of circumstances happening. So that's, it talks a lot about notice to the tribe, and it talks about at the beginning of each proceeding. It's the wording that is actually used. And generally we say if there's going to be a change in placement, a change in some kind of major circumstance, yes, you do need to be letting the tribe know. Can the tribe petition as a party to potentially transfer to tribal court? Yes. So transfers can happen to tribal court in any point in the hearing. So that's one thing that has come up, and that it was talked about specifically in those regulations that came out. Transfers can happen at any point. Now, again, I will caution you, I'm talking from the federal language. I'm going to talk to you from a best practices recommendations point. Look at your case law in your state to see if there is case law that limits or expands upon these issues around transfer. There are some, so this is in guardianships. So are you talking about the potential of the guardianship changing? Or that it could potentially, okay, so if the guardianship could potentially change, yes, because that would then lead to a potential change in placement for the child or change of circumstances. That's the big thing that you want to be looking at. And I hope I'm understanding your question appropriately, and if it seems like I might not be, shoot me an email later and let's talk more offline. But anything that constitutes a potential change in placement for the child or a change in circumstances for the child, and this tribe is going to be involved in some way, it's important to keep them apprised of these changes. There were a lot of cases that happened where people tried to claim, oh, well, we let them know when we made the initial decisions, and then down the road, a lot of things changed and the tribe was never apprised, and suddenly they're losing children, or they're not aware, or there's some new proceeding that's taken place and people in the state think that they're in the loop and the tribe's just not participating, but they didn't even know that anything changed. So as an attorney, I always err on the side of caution. I always say I would rather make sure I'm providing this information than find out later that I did not provide enough information and now we have to go back and handle things retroactively. I hope that that's clear and that is helpful to you, Ellie. And like I said, you can get my email at the end, and if there's more specifics you want to talk about, I'm more than happy to talk about them with you. I had many years ago. My tribe provided it. Okay, Stacy, yeah, sometimes that's been done. You're welcome, Ellie. Sometimes that's been done where the tribe will provide the expert witness. I mean, if no one's going to object to the expert witness's testimony, then it's probably going to be allowed. I know that they do have the opportunity to question. So if you have a parent's attorney can question whether or not a qualified expert witness is an appropriate one, as can other parties in the case. I think that for a long, long time, states were really relying on the tribe to provide qualified expert witness testimony because they just didn't know how else to get it. I just wanted to highlight the point that it's not the tribe's responsibility to do it. if the tribe does have one and provides it to the state and allows them to use that, and that's the agreement that you all have made, then that's the agreement that's been made. I've actually been in hearings where there was a qualified expert witness that clearly should not have been allowed to give qualified expert witness testimony under the requirements of what is a QEW, and nobody questioned it, and it was allowed, and it wasn't my case, so I didn't have the ability to stand up and say anything. Having the tribe involved in getting a qualified expert witness, or at least approving a list of people or doing something like that, can sometimes reduce the chance that the QEW that is chosen will be disqualified. I know that the QEW thing is super complicated, so I think we'll talk about it a little bit more in a minute. I mentioned that there is a good cause to deny transfer. Here's the exact language. I want to make sure you have it. First of all, if someone wants to deny transferring to a tribal court, they have to state it either orally on the record or provide their reasons in writing. Those reasons have to be provided to all parties. And the party that wants to not transfer has the burden to prove by clear and convincing evidence that there's good cause not to transfer. So if anyone is saying we think there's good cause to not transfer to tribal court, you still have to prove it by clear and convincing evidence that that's so. And here's, instead of saying what good cause is in the regulations, they decided to say what good cause is not. So here is the list of the things that you may not say are good cause to not transfer. So first of all, if the proceeding has gotten to an advanced stage and the party did not receive notice until that advanced stage, you can't then say, well, too late, it's too late to transfer. We are already at TPR. Well, yes, but we as the tribe or we as the parents didn't even realize that we were at the TPR stage until now. Saying, well, it's too late, it's too far down the line, when they never received their appropriate notice is not good cause to not transfer. Another one, there were prior petitions involving this child and the court didn't transfer those. Well, sometimes, as I mentioned, the court is going to hold back. The tribal court might say, things are going well, we're working with the state, we're comfortable with things are, we don't want to disrupt anything and transfer yet, but now we're at a certain point and we do want to transfer. Simply because they did not choose to transfer before does not mean that that's suddenly good cause to deny the transfer. The tribal court may have a valid reason for having held off until a certain point in the hearings. Another thing is you can't say, well, we don't know if we like who the potential placements are going to be. That by itself is not a good cause to not transfer. If someone doesn't like the potential placements, I mean, the parents can argue that in tribal court just as easily as arguing it in the state. And quite honestly, I have seen numerous transfers to tribal courts where they just allowed the placements to continue as they were because they didn't want to cause a disruption. Sometimes that doesn't happen. I fully recognize it, but that by itself is not considered good cause to not transfer. Another one is the child's cultural connections to the tribe. That goes back to the point I made in the beginning where sometimes people get confused and they think, oh, well, this is some kind of racial or ethnic thing, and if they don't go to cultural celebrations, then why would we be sending them back to their tribe? But if you remember that we're talking about political identity, we're talking about membership in a tribe, that doesn't, you can not participate in anything cultural but still be a member of a tribe. There are other things that that come along with memberships in tribes. There's voting rights down the line that have to do with the ability to govern and self-govern as a tribal nation. There could be potential lands involved that a family had down the line that this child could have access to. There can be educational opportunities and other types of opportunities that are specific to their membership in their tribe. It goes so much beyond whether or not they wear regalia and participate in a feast or a powwow or some other type of cultural activity. So again, by itself, that is not considered good cause for not transferring. And then finally, socioeconomic conditions or perceived inadequacies. sometimes people might look from an outside perspective at a community, and what they are perceiving as an inadequacy, if they were actually living there and living among, would start to realize that that is coming as an outsider looking in. And that by itself may not tell you how much love, how much support, and how happy and how comfortable that child could be in their placement. What is looked at as good cause? So that one's trickier. The reason they put what is not is they want to allow for some judicial discretion in determining what is good cause. So they took some of the things that have been sort of abused arguments in the past and they listed them. And then if you as an attorney think that there is good cause and it's not one of the things that have been specifically stated as not, you can make a case to the judge, and then the judge will determine whether or not you demonstrated that by clear and convincing evidence. So I don't know that I can necessarily give you an example of what is good cause. There are times when someone will say there is good cause to not transfer, but the important thing is that you have to be able to prove it. You have to be able to demonstrate it by clear and convincing evidence and convince the judge, and the judge has some discretion on determining what that looks like. Sorry, I can't give you more than that. This is the thing with family law. This is why I'll often say to people who don't practice family law, sometimes we practice some of the most difficult law because there are a lot of ambiguities, gray areas, relationship issues, and especially when you're dealing with child welfare and other types of dynamics, it's very hard to get a lot of black and white standards coming out, and the judges are allowed a little more discretion in some of these cases as long as they're following the black letter requirements. I want to pick up this pace here. So we also talk about more rigorous efforts to promote reunification. So if we are saying that it is traumatic to be removing a child, and it is traumatic also to be completely terminating parental rights and getting rid of those relationships, ICWA actually promotes rigorous efforts toward reunification, which is, again, something that within the child welfare world is looked at as a very positive thing. So the first, and the one that we talk about a lot, and again, another ambiguous term, is active efforts. So you have to be able to prove that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, and you have to show that those active efforts were unsuccessful. Now the question always comes up. What is active efforts? And you all are going to hate me because I can't give you, again, a black and white, just like I can't tell you exactly what good cause to not transfer is. It's also hard to tell you exactly what active efforts are, but I will give you some guidelines that you can look at. First of all, they have to begin at inquiry. The moment there is a reason to know that you have an ICWA case, active efforts need to begin there. Here's why it gets tricky. Active efforts need to be tailored to the facts and the circumstances of individual cases. So something that might be active efforts in one case may not be active efforts in a different case purely because the circumstances of that particular family is going to be different. So one example I'll give is that maybe a reasonable effort, which is your normal efforts that are required under cases that are not ICWA cases, could be mom needs to go to a substance abuse counselor. We're going to provide mom with a list of some potential substance abuse counselors that could be useful, and we'll check in to see if mom has actually gone. An active effort might be, here are the names of some people, and we're going to actually help you call and set up this appointment. And do you need any kind of assistance in getting to your appointment? So that could be the difference between what would be looked at as a reasonable effort and what would be looked at as an active effort. But because it's supposed to be tailored to each individual case, it is hard to give a lot of examples of exactly what that means. What you do need to look at is, are they affirmative, thorough, and timely actions? Those are three words that they're going to be looked at when you're trying to determine whether or not it's actually active efforts. Were these active efforts designed specifically with the intention of reuniting the child and family? And then, and this is something that is new that came out in the regulations, the active efforts need to be documented in detail on the record. So as attorneys, you may have noted more judges asking for more documentation. It doesn't have to necessarily be an oral recitation in court on the record, but at a minimum, it needs to be a detailed report or something that can be given to the judge that can be included in the formal record. So if somebody comes back someday and says, what was actually done? We want to know if this was active efforts or not. They want the detail in the record so that someone can go back and look at that and make a determination of whether it's active or not. And then we mentioned the importance of kinship placements. ICWA does promote efforts toward more kinship and community placements purely right away through its placement preferences. So right in the law, it talks about foster care and what type of foster care placements are the preferred placements under the Indian Child Welfare Act. So this is the list that you're going to find in the thing. You want to start with extended family placements, which I think that most of us will agree is generally going to be your first choice for any child. So that's the first choice in an ICWA case. Then we're going to look at foster homes licensed by the tribe. There are more and more tribes developing their own foster care programs. If you have tribes near you and you don't know if they have one, reach out and find out, because a lot are starting to grow and develop their own foster care homes. The third choice then would be an Indian foster home that was licensed by the state, then institutions provided by the tribe, and then finally, and that's other foster homes licensed by the state are not considered preferences. They are considered the default if you can't get them in one of the preferred placements. And we know, those of us who work with child welfare, it is hard sometimes to find a family member who is fit and willing, or to find one of these other preferred placements. They also have placement preferences related to adoptions. So again, members of the child's extended family, other members of the child's tribe, other Indian families, those are your preferred placements. And then if none of those are available, then other placements. And then just like with transferring to tribal court, there is a good cause requirement if you don't want to, if for some reason you're saying we're not going to be following what are considered placement preferences for either the foster placement or for an adoption. So if you're saying that we are not going to be following the placement preferences, we want to place this child in something that is other than a preferred, first of all, again, it has to be stated on the record, either orally or provided in writing to the parties. And again, the party that wants to depart from the placement preferences has the burden of proving by clear and convincing evidence why they will not be following the placement preferences. And then here are some good cause considerations. One or both of the child's parents could request for a placement preference to not be followed if they attest that they have reviewed the placement options. So then they can bring that to the judge and say, we've looked over all these options and we really believe that there's a good cause to not follow the preferences in this case. Also, if the child is considered of sufficient age and capacity to understand, and that of course is different from state to state depending on what your standards are, and the child personally requests it, that could be looked on by the judge as a good cause to consider not following placement preferences. Another one is there's a sibling attachment, and the preferred placement would not allow the siblings to stay together. Then you can bring that to the judge and say, this placement is going to be separating siblings. We're very concerned about this. This seems to be a good cause to make a change. If the child has some type of extraordinary physical, mental, or emotional needs, and a placement would change that up and make it difficult for those needs to be met. And then this is the big one that often happens, which is there was no suitable placement. But you can only consider that a good cause argument if at first there was a diligent search conducted to meet the placement preference. If we work in family law, we know diligent search has a particular meaning. It can't simply be, we called a couple people and they said no. We actually have to be able to demonstrate a diligent search was conducted, and at the end of that, there was not a suitable placement that met any of those placement preferences. And then there are actual standards for what we mean by suitable placement. I mean, we're trying to try to give us more guidance and more assistance with complying with the law. So suitable placements generally need to prevail with social and cultural standards of that child's community. I am Ojibwe. That means that if I were a child and someone was looking to place me away from my family, they would want to be looking for another Ojibwe or Anishinaabe family to put me with, not necessarily an Apache family. We have different cultural standards. Now, if there's no Ojibwe family and there's an Apache family that's close by, their cultural standards may be closer to my tribal cultural standards, so that may still be a good fit. But we can't just assume because someone is Native that they automatically are the first choice. We want to start with that child's own culture in their own community. With 573 federally recognized tribes, some are related and some are connected, but that's a lot of different cultures and a lot of different things to be aware of. And I know that that can be overwhelming for people who are not in the community, so that's why I'm trying to give as much assistance and guidance on some of these ideas and these standards as possible. You also have to remember you're not supposed to depart from a preferred placement purely based on socioeconomic standards between one placement and another. I know it's very easy to make this argument, well, this person may not be the preferred placement, but look, they have so much more money and they can do X, Y, and Z for this child. But money alone, as we found from these adult adoptees telling their stories, is not necessarily a replacement for culture, is not necessarily that thing that helps deal with that sense of loss of not being able to be raised in your community and going back as an adult and the depression and the sadness and the sense of loss that has occurred. So that by itself shouldn't be what we're looking at when we're looking at what kind of love and quality they could have despite the economics. Also, this is a big one that comes up and can be really controversial, but simply because there was some ordinary bonding and attachment that occurred because a child was in a non-preferred placement in violation of ICWA, suddenly saying, well, then we don't want to move them to a preferred placement. There's actually a lot of sociological research, and social psychologists are writing books now on bonding and attachment and telling us that we've actually not been looking at bonding and attachment correctly. If a child bonds and attaches, that is really wonderful. It shows that they do not have a bonding and attachment reactive disorder. And if they have bonded and they have attached, obviously any type of transfer can be hard, but it's also the sign that they will bond and attach again. So I can get some people citations. First, I'm an attorney, so I am just telling you some of the things that are starting to come out in the social sciences, in the research done in child development. There are sources out there that we can absolutely send to you if you want to read more on that. But the point is, if the law was violated and a child was placed in a non-preferred placement at one point, simply saying, yeah, but they're attached, by itself, according to the law, is not a reason to not now get them in an appropriate preferred placement. So I know I don't want anyone throwing like rotten fruit at me, even though I'm on a computer and you can't, but I understand that this is a very sensitive and difficult issue. I am a mother, I am a grandmother, I get it. Nobody wants to see a child suffer and be sad because of things, but I just want you to tell you what is in the law when it talks about suitable placement standards and putting kids in preferred placements. We mentioned quickly, I'm going to just quickly touch on voluntary placements. A voluntary placement in which a parent consents to foster placement or seeks to permanently terminate their rights or place the child in a pre-adoptive or adoptive placement is covered by ICWA. So if there's any question, it is. Those are ICWA cases. And it's also important to know that there are some standards about voluntary placements. So if a parent or an Indian custodian says we want to temporarily place this child out of home, or I want to voluntarily terminate my parental rights, first of all, the consent to that placement cannot happen prior to or within 10 days after birth. So that is an important thing. There is no bedside person who's made a signed agreement before that child is born or within 10 days of that child's birth, or that is not in compliance with ICWA. The consent has to be in writing, and it has to be recorded before a judge, where the judge has to be able to make sure that the parent understands what they are agreeing to do. So This is a really important thing because there were predatory people out there who were starting to prey on very vulnerable people who were just getting ready to give birth. So this standard is in there. If those standards are not met for voluntary terminations and voluntary placements, we have to make sure that those are met to be in compliance with the law. I am attorney. Yes, Phyllis. What I will do is I'm going to give some of the references about the bonding and issue and attachment issues that I've been reading to maybe Alicia, and it could be sent out to the people who registered for this webinar. So yep, she's given me the thumbs up that she can do that. So what I will do is in the next few days, I'll get her a few of those references that you all can look at, and I know there's at least one publication that should be out sometime in 2019 specific to ICWA and bonding and attachment that I will just say be watching for. So Phyllis, I will make sure that that is sent out to everybody. Thank you for asking. Let's see, whoa, we have 10 minutes left. Let's see how many more of these slides I can get through. Did anyone, if you've ever heard me speak before, of course, Phyllis, you're very welcome. I get really excited about talking, and I'm really glad we've been able to be interactive. You can look up a lot of the information I'm talking about. The National Council of Juvenile and Family Court Judges has an ICWA bench book that has a lot of these things written in it and that you can have access to online, and you can also write NCJ, FCJ, and have a copy sent to you for free. So there are ways to look this information up that we can't get from this type of interaction. Also, just so you know, with voluntary placements, if they do not prohibit a child's parent or Indian custodian from regaining custody upon demand, then that would not be an ICWA case. So if they're saying, we're going to put this child in this program, but if I write them and say, I want my child back and I don't have to jump through any hoops to get my child back, then that type of voluntary placement is not an ICWA case. Where situations which a private person? Generally, no. Generally, active efforts is a standard on the state. Just like many people don't realize, the Indian Child Welfare Act is not something that tribal courts are required to comply with. It is something that state courts are required to comply with because it's specifically focused on remediating damages that were done in the past when the state was taking a lot of children away. There are tribes that have adopted ICWA and ICWA standards, but I have not heard of that. That's generally something that a state social worker has to be able to prove. They made active efforts to prevent the removal. I hope that helps. We talked quite a bit about QEWs, so I won't spend a lot of time on it. I just want you to look at the language. Remember, the QEW needs to be qualified to address whether they think continued custody will result in serious emotional or physical damage to the child, but they also need to be aware of the cultural standards of the community. One of the problems in the past is experts will come in and they'll start addressing whether or not they think the child should stay with their family or their community, and they know nothing about the community standards, so they were applying an external standard that wasn't appropriate. So that is one of the main reasons why a QEW was put in the first place. Someone mentioned whether or not a tribe could provide one. Well, they could at least designate one if they would like to. Also, if you're having trouble finding one, you can contact the tribe to help you. You can go to the local Bureau of Indian Affairs office to see if they can help you locate a qualified expert witness. And this is one thing that's important. A regularly assigned social worker, and by this, in practice around the nation, it looks like the standard is the state social worker. A regularly assigned state social worker may not serve as the QEW. But I have heard that in some places, the tribe is having the social worker that the tribe is kind of having do concurrent planning efforts with or case planning efforts with the state, that sometimes they will serve as a QEW. And of course, there's rights to timely examine all reports and documents that are filed with the court. There have been cases in the past where tribes were having a really hard time getting the documents, and by the time they did, they ended up missing being able to file appropriate documents in the case. So the regulations simply stated what we all should hopefully know. And this best chance to minimize trauma, I'm not going to spend a lot of time on these slides. The slides are available in that PDF if you want to look them over. But unfortunately for American Indian and Alaska Native children, the child abuse and neglect rates are very high around the country. Our disproportionality rates for foster care are also incredibly high. And in fact, of any group that is studied as a group, American Indian and Alaska Natives have the highest percentage compared to their numbers in the population of children in out-of-home care of any other group in the nation. So there are a lot of, I don't have time to get into some of the historical trauma issues, some of the pervasive poverty issues that some of our tribal communities do face. But all these things create a really difficult situation where we find a lot of American Indian and Alaska Native children placed out of home. This is a disproportionality rate over time. It only goes up to 2013, but it took the two groups of children that are most often found in out-of-home care and most disproportionately found in out-of-home care, which are African American children and Native American children. And if you notice, while both groups are still disproportionately represented in out-of-home care, the rates of the Native American children are continuing to go up. African American children are still absolutely disproportionately placed, but their rates were starting to improve a little. There are a lot of reasons for why that may be happening, but I think it's a red flag for those of us who work in child welfare that there are things going on that even with the Indian Child Welfare Act, it's not being complied with. It's not being followed. We have standards in that law designed to try to reduce the amount of out-of-home placements, and when we're not complying, it's not happening. So going back to where we started, think about those standards. Those are child welfare standards across the board. I hope that by talking about it in that way, it helps us see that some of the things in ICWA, they're not designed to make your job harder. They're not designed to be burdensome. They genuinely do represent some of the best and most cutting-edge research that we have on child welfare. And by following them, we can absolutely help reduce those disproportionality rates and reduce the levels of trauma on American Indian and Alaska Native children and families. So here is my information, and I will turn this back over to Ansley, and thank you all for being so interactive.
Thank you, Victoria. That was a fantastic presentation and really informational. But before we conclude, I just wanted to take a moment to talk about NIJA and our work in tribal communities. As some of you already know, NIJA is a tribal justice professional organization whose goal is to build tribal court capacity. We do a pretty broad range of work for tribal communities, including training and technical assistance to support tribal courts. We're also TA providers for the Bureau of Justice Assistance Task Purpose Area 3 grantees. This webinar was funded through our Tribal Civil and Criminal Legal Assistance Grant. And if you'd like to be added to our email list so you can be notified about future webinars like this, just shoot me an email and I'll make sure that that happens. We have other webinars in the works and we'll be sure to let you know about those as they come up. Another part of our work is the Tribal Access to Justice Innovation website. This website allows us to highlight and share different programs in tribal communities. So if you know of a promising program, let us know about it, and if it's not already highlighted on our website, we can go ahead and share it. That website is tribaljustice.org, and again, our goal with it is to learn about emerging practices and share that information so as many tribes are addressing those common challenges. And that concludes our webinar. My email address is ansley@nija.org. If anyone has any questions or TA requests, just like I said, shoot me an email. Otherwise, thank you to Victoria Sweet for your presentation and to NCJ FCJ for hosting. And thank you everyone for joining us today.